Okay.
So this is 9th October 2024. This is Civil Litigation April 2024. This the Zoom meeting is done ahead of November 2024 exams, and it will be uploaded on the by exam preparation website, by exam preparation YouTube channel. So yeah, so the papers, if you want to if someone want to pass in civil litigation, you must do the following. Number one, this is my opening. You
Mm-hmm.
must Civil Procedure Act, read and understand it.
Mm-hmm.
Civil Procedure Orders 2010.
Mm-hmm.
How to approach court, very, very important. Petition paints, chamber summons, originating summons, notice of motions, or where they applies. In fact, you should someone should do a matrix on that, those all those things.
Mm-hmm.
And in my oros Q&A, I did some for some of these pleadings.
Mm-hmm.
You must know how to draft. Drafting is a skill. When you identify the pleading, drafting is a skill. So you must know how to draft. And correct timing. Use the correct time as per indicated in the exam paper. So the more the marks, the more the drafting. So if it is a question of 20 marks or 15 marks, those are 3 drafting. A question of 10, 12 marks, those are 2 drafting. Maybe a pleading and it's a affidavit. If it's a question of 5 marks, you do only the pleading, only the pleading. So the marks helps you to know how long the document you are going to draft is.
Mm-hmm.
You must know the timelines. Civil litigation is guided by timelines. For example, if you are served with a plaint
Mm-hmm.
as a defendant, how many days do you have to reply? So limitations of time. These cases must be filed. Each and every case must be filed within a given time after the cause of action arose, for, except petitions,
Mm-hmm.
breach of fundamental breach of fundamental rights and freedom, which does not have limitations of time.
Mm-hmm.
If you are appealing, what is the time you are going? See that from the time the decision is made, what what time do you have to appeal to the magistrate court, to the high court,
Mm-hmm.
to the court of appeal, to the Supreme Court? So
Mm-hmm.
you must know all these timelines,
Mm-hmm.
and the documents. Finally, you must know the correct forum to
Mm-hmm.
file your case. For example, if you know that there are the cases that start at magistrate court, the pecuniary jurisdiction of magistrate court is capped at 20,000 and 20 million, and that is Magistrate Court Act, Section 7. And below that, there are pecuniary jurisdiction of resident, principal magistrate, all those you need to know. When you go to the High Court, you must know the different kind of High Court divisions. Here are different cases. There is judicial review. There is constitutional and human right. There is civil division. There is commercial and tax. There is those you must know that if it is an employment and labor relation matter, it goes to Employment and Labor Relations Court. If it's a land matter, it's go to Employment and Land Court. So it's very, very important. Every time you are tackling a civil litigation, you must know those things I've talked about. Those 5 things. So now we go now to the substantive matter of the day. So this is question 1. Yeah, of April 2023. April 2024. It is the most recent paper done. So I'm going to read and then we are going to tackle the question. So I'm going to read. So on 14th March 2023, Gifted Spirit General Limited and Happy Limited, the bank, executed two debenture agreement in respect to various machineries owned by Gifted Spirit General Service Limited. The bank extended credit facilities to the company for collective sum of 61 million. One debenture agreement was specific in respect to a refinery machine known as Guard Motor Series, valued at 45 million. The other debenture agreement was generally for any other property machinery owned by the company but not specified based on a specific debenture agreement. Save for the difference in type of properties covered in each of the agreement, most clauses in the two agreements were striking identical. Clause 7 of both agreements stipulated that the principal sum was repayable within 1 year, plus profit with a monthly installment of 10 million to cover for both profit and interest. The two debenture agreements were subject to provisions of Movable Securities Rights Act. The sole director of the company also signed a separate agreement as to the grantor to personally bound with the meaning of the Movable Property Security Rights Act. The company defaulted but instead sued the bank on pretext that the bank was in process. So all these things yeah, so now the question start here because this is civil litigation. The company defaulted the company defaulted, but instead sued the bank on the pretext that the bank was in process of selling all the company assets through the public auction scheduled in the next 2 weeks. To the contrary, the company had defaulted by not remitting any periodic sums and also clandestine sold the refinery machine known as valued at 45 million without the knowledge of the bank. The bank had intended to exercise its right to sue the secured creditor under Section 68 of the Movable Property Security Rights Act for the plaintiff's wrongful act of selling the property without the knowledge and concurrence of the bank and default by the plaintiff. All the company assets as which are subject to the both agreements are in Nairobi, but the agreement was signed in Mombasa. The company place of business is in Kisumu, whereas the bank price is traded in Machakos. The plaintiff filed the company reads as follows. Republic of Kenya, Chief Magistrate at Kisumu. That case, the company is called Gift Spirit General Service Limited, the plaintiff, and the bank is called Happy Valley. So the plaintiffs read as follows, which the company sued. So the plaintiff is a liability company due incorporated and the relevant provisions of the Companies Act number 17 of 2015 currently carrying out its business within Kisumu County. The plaintiff address of services suit are Messrs. Wakili, Advocate LLP, Faithful New Wing PO Box, that Nairobi. The defendant is a limited liability currently providing banking services within the meaning of Banking Act Cap 488 of Laws of Kenya. The plaintiff avers that on 14/3/2020 executed two debenture agreement within the defense in respect to various machineries owned by the plaintiff. The plaintiff further avers that pursuant to the debenture agreement, the extended credit facility to the plaintiff for a collective sum of 61 million. The plaintiff stands to earn that the debenture gives specific respect of a finite match known as Grand Motor Serio, valued at 45 owned by the plaintiff. Another two debentures were general for any other property material by the specially mentioned in the specific debenture agreement. Several of both agreements stated that the principal sum were repayable within 1 year plus the profit within a monthly installment of 10 million to cover both profit and interest. It is also understanding that the parties that the two debenture agreement be subject to provision of Movable Property Security Rights Act. The plaintiff stated that its honored its obligation under the debenture agreement that it does not owe the defendant any sums under the agreement. To the plaintiff after dismay, the defendants are without justification whatsoever purported to schedule a public auction of the plaintiff assets on that date, 20th February 2024. The plaintiff is apprehensive that the defendant will proceed with the impurged auction unless the honorable court interferes. The plaintiff served the defendants with a letter of demand prior to action, but the defendant ignored their rendering this suit necessary. There is no suit pending between the plaintiff and the defendant of the subject matter, and there have never been such civil action determined between the two parties. This court has jurisdiction to entertain the suit. Reason whereof the plaintiff prays that a declaration that the plaintiff is not indebted to the defendant under the two debenture agreement executed on 14 March 2023. An order of permanent injunction is restraining the defendants from selling the plaintiff assets on 20th February 2024 or any other subsequent public auction. Cost of the suit be borne by the defendant. Dated that day, drawn and filed to be served upon. So, advise the bank on the question 1, advise the bank on the defects in the pleading and what should be done to have the suit struck out in limine, 5 marks. So, what do you understand by this question before even we go to the substantive questions themselves? After you had read.
I think the question is asking whether there were any errors in the plate.
Sorry?
The question is asking whether there were errors on the plate.
You are breaking. I don't know why.
Can you hear me now? Am I still
yes,
breaking?
now I can hear you. Now I can hear you.
The question is asking whether there were errors in the plate.
No, not even before even we go to the question. I want you first of all. What did you understand by this? By all this? Yani, you understanding after you have read this?
That there was.
Yani, that you narrate. You narrate the question in a bright version. Yani, small version. Just understanding quickly.
Okay. So the parties there, what is the name? Could you please scroll a little? I want to see the name of the party. Yes. It was like there was one floating charge because it was going to. In the first agreement, there was no specific property that the charge on which the charge had been created. And in the second one, there was a specific charge because there was a specific property that had been charged. In total, the what is the name again? Gifted Spirits had secured 61 million shillings. So the charge was in exchange for 61 million. They were supposed to return this money at some point to pay the money back to the bank, but they defaulted in payment. And at the same time, they ended up selling the property that was charged in the specific charge. So the property was sold, and then the bank tried to make inquiries about what had happened. Gifted Spirits turned against them and went and made it seem like it was the bank that was trying to unlawfully sell property that had been charged, the property that had been charged. Yet it was type of sale. Once you default in payment, it is automatic that you have the right to sell. But at this point, the Happy Bank was late in filing a suit against Gifted Spirits. So Gifted Spirits went and filed a suit ahead of them and denied that there was an agreement of that kind, that charges had been created over the property, and claimed that Happy Bank was trying to sell the property unlawfully. Yes.
So that is good understanding. Yeah, so you have understand. So this gift spirit general, you must answer. You must understand the question in context of the subject. So if it is a conversing question, you must each and every question has a very long story. Whether it's probate, whether it's legal writing and drafting, whether it's civil litigation. So this is civil litigation. This is a very long story. So you must know what is and you understand it so that it can help you to answer this question in terms of civil litigation. So the company, this company Gift Spirit defaulted. So after they had defaulted in paying, so they went ahead and sued. No.
Yes.
So they do not have a right to sue. It is the bank who had a right to sue. Unaona?
Yes.
So so it's them who had the right to sue or exercise their power. In now that this is conveyancing. Either sue when movable properties security act is commercial.
Yes.
They had a right to sue now. But the company defaulted, then sued. So having that understanding, now you can answer the questions. So advise the bank on the defects in pleading and what should be done to have the suit struck out in limine. So what are the keywords here?
Defects in pleadings and struck out.
Struck out in limine.
Okay.
So what is your answer? What do you think?
I think there is a problem with jurisdiction.
Yes.
The decree, okay. The value of the subject matter is 61 million.
Okay.
The amount that was secured is 61 million. Even if we go to the specific property that was sold, it was 45 million.
Okay.
The Chief Magistrate's Court can only handle matters where the subject matter, the value of the subject matter is up to 20 million. So beyond 45, anything above 20 million is beyond it. Only the High Court can handle it.
As she had tried to say, the jurisdiction or magistrate courts cannot hear this claim because it is more than the jurisdiction of the magistrate court. So this case ought to have gone to the High Court, Commercial and Tax Division. So that is one of the defects in pleading
Okay.
Sawa, continue.
I was saying that the High Court
Uh-huh.
will deal with that matter because it is beyond the Chief Magistrate's Court. Anything above 20 million goes to the High Court.
Okay.
So in that case, that is the first defect.
Okay.
Also, I'm not sure about this one, but I believe
Okay.
there's a time. But no, that's not a defect. Let me leave that one alone. I'm not sure about that one.
Okay.
Yeah, I think that's the defect I can note for now.
Okay. So that is one of the defect. So the other defect is the place where of course it ought to have got to the High Court Commercial and Tax Division, because the Magistrate Court do not hear matters which pecuniary jurisdiction is more than 20 million, and the claim here dispute here is about 45 million. Then the place where the case is supposed to be taken to be sued. So the case was now supposed to be sued in Kisumu. And it was supposed to be taken in either where the contract was company assets, where they were subject matter, either in Nairobi or where the defendant resides. That is Machakos town.
Okay.
So the backing of this is Civil Procedure Act. Section 11 to 15. So I want to project it. You can even be having those things, the things there. Be having this document. I'd have good device, a laptop.
Okay.
Yeah, laptop is best because of a good view. So I want to project now the Civil Procedure Act. It is one of the things that someone must understand. So I'm now sharing. So the place of suing, very, very important. So you can see Civil Procedure Act. You can see Civil Procedure Act.
Yes, I can see it.
So this is a place of suing. So section 11. So every suit shall be instituted in the court of the lowest grade competent to try it. So that is one. So the case should be instituted in the lowest grade of which is competent to try it. Yeah, and say other things, but that is the most important thing. Section 12, suit to be instituted where the subject matter situate. So subject to pecuniary or other limitation prescribed by any lawsuits for recovery of immovable property, with or without rent for partition of immovable property, where the property is situated in cash, shall be instituted in court within local limits whose jurisdiction of the property is situated. So, in our question here, we are being told the property is in dispute is the debenture property. The nini was situated where?
I think in Nairobi. Remember the contract was signed in Nairobi. I don't remember.
The company are subject, which were subject of both agreements, are in Nairobi.
Okay.
So that is one of the options. So the section 12, you say section, it was not nini brought to the either you sue where the subject matter is, if it is immovable, or where the defendant sued for immovable property situation within jurisdiction of different courts. So section 13, where suit is to obtain relief in respect for compensation for wrong of immovable property situated within local jurisdiction. The suit may be sued in the court within the local limit. So if it is immovable property, like land, you sue where the land is. Well, if it is immovable, like the one for, because if it is movable property, also you sue where it is. So suit for compensation for wrong to the person or movables. Where suit is for, now section 14, where suit is for compensation of wrong done to a person or to a movable property. If wrong was done within local jurisdiction or court, and the defendant decides to carry business or personal works for gain within the local limits of jurisdiction or another court, the suit may be is suited at the option of the plaintiff in either of those courts. So, where suits for compensation for wrong done to a person or to a movable property, if the wrong was done within local limits of jurisdiction of one court, and the defendant resides or carries out of business or personally works for gain within the local. A residing in Mombasa, B to be in Nairobi. B may sue either in Mombasa or Nairobi. A residing in Mombasa publishes at Nairobi statement which are definable to B. B may sue A either in Mombasa or Nairobi. Other issue to be instituted where defendant resides or cause of action arose. Subject to limitation oversight, every suit shall be instituted in court within the local limits of jurisdiction. The defendant or each of the defendants where one or more time of commencement of the suit actually and voluntarily resides or carries business or personally works for gain. Or any of the defendants where one or more a time for commencement of the suit. So that is it. So you once needs one need to read section 11 to 15 on place of suing. So generally, in short, if it is you sue where the assets are, or where the defendant reside or do business. So this case also to either to have been sued either in Nairobi because that is where the company asset were, or place of business of the bank, which is Machakos. So there is no way the plaintiff sued in Kisumu, where he reside. So those were the two answers. We are together.
Yes.
So that was answer to number A. And there is a difference between, it can come as a question, this one. There is a difference between a suit being dismissed and a suit being struck out. So when a suit is dismissed, most of the time it is hard on merits,
Mm-hmm.
so it cannot be brought again. So you appeal.
Okay.
So, but when the suit is struck out,
Mm-hmm.
the suit is not determined on merit. It's a preliminary thing. Most of the time is a defect in law.
Mm-hmm.
Yeah. So that was the answer. So draft the appropriate pleading that you file on behalf of the bank to realize the bank intention at the A above. So after knowing that the defects in pleadings are those place of suing is wrong and
Mm-hmm.
the court is wrong.
Mm-hmm.
So now you draft your pleading.
Mm-hmm.
Now I want to project your pleading.
Okay.
So it's good to be sending in advance,
Yes.
so that I can arrange them and name them.
Okay.
So now I'm sharing your drafting.
Mm-hmm.
So
Mm-hmm.
in an exam, if you are told to draft a question of 5 marks,
Mm-hmm.
this question, the question is very direct. Draft the appropriate pleading that you file in behalf of the bank to realize the bank's instruction.
Mm-hmm.
I'm not sure if you have time to draft the affidavit.
Mm-hmm.
So if it is a question of 5 marks, I would advise you leave the affidavit.
Okay.
You do only the the pleading, and when you do the players and the grounds, that is enough. You get 5 marks.
Okay.
So of course the appropriate pleading was a notice of motion.
Mm-hmm.
You quoted order 2 rule 15. What
Mm-hmm.
does order 2 rule 15 say?
I know it has to do with suits being struck out
Uh-huh.
where the where the grounds when the hearing is going to be an abuse of process, will amount to an abuse of process if the suit is based on baseless grounds.
Okay.
They like using vexatious and all those
Yeah, yeah.
words, but when there is no cause of action
Mhm.
or defense.
Yeah. So that is very good. Striking out of pleadings.
Mm,
At any stage of proceedings, the court may order struck out or amended any pleading on ground that it discloses no reasonable cause of action. It is scandalous, frivolous, and vexatious, and it may prejudice or delay trial. It's otherwise an abuse of court process and may suit be stayed or dismissed. So that is good. Order 2, Rule 15.
mm,
Yes. Then you can also put Order 51, Rule 1.
okay.
Anytime you don't know the correct order,
Mm-hmm.
because all notice or motion are brought at the order 51, Rule 1.
Okay.
So uh, of course, the applicant is Abe Bank Limited and the Gift Spirit General Services Limited. Good. And order 2 Rule 15 of Civil Procedure or a number Take notice that this honorable court shall be moved on. You date the day of the exams.
Okay.
Yeah. You don't date the day, you leave blank, eh?
Okay. Okay.
Because this is going to be filed in court, they are going to give you the date. But you
Okay.
any pleading you sent on the date of the exam, eh?
Okay.
So you leave blank at 9 a.m. and 4 noon or soon thereafter, as the Council for Africa seeks to be heard for orders that the suit be struck out, that the cause of this application be the cause. So those are good. Those are the two prayers. Good. Which application is founded on the following ground, on the supporting affidavit of Muli Munye and the following grounds. So here you put the legal grounds. You remember our last class
Yes.
that this court lacks jurisdiction to hear the matter. So after you say that,
Yes.
you explain why this court does not have the jurisdiction to hear the matter. You say
Okay.
that the case was filed in the Chief Magistrate Court in Kisumu, which does not have jurisdiction to hear. Yeah, so you explain
Okay.
that this suit has no merit and is founded on error. Why? You explain it is the
Okay.
defendant, it is the respondent who in fact owes the applicant money and is not the other way. Now,
Mm-hmm.
you explain that. Then it's you go to what I have said.
Mm-hmm.
That the place of suing is wrong.
Mm-hmm.
This case ought to have filed in Nairobi, where the subject matter is or or be sued in Machakos, where the applicant reside or do business.
Mm-hmm.
That the suit is an abuse of court process. So you date the day of exam, you sign,
Okay.
you Mutinda and company to be serving that. So that is how you are supposed to be done. When you do the prayers where the heading, where the parties, the grounds, you get 5 marks.
Mm-hmm.
Don't do an affidavit in a question of 5 marks. You waste a time.
Okay.
So that was that. This one you have really tried.
Mm-hmm.
So we go to the next question. The next question. So the next question is, the bank still intends to exercise its right to sue as secured creditor under Section
Mm-hmm.
68 of the Movable Property Security Rights Act for the plaintiff's wrongful act of selling the property without the knowledge and concurrence of the bank, and the default by the plaintiff, as the bank has instructed you to proceed. Assuming there is no defects in the plaintiff suit, draft the relevant pleading to take care of the bank interest, noting the appropriate forum. So there are keywords here.
Mm-hmm.
You assume
Mm-hmm.
there is no defects in the plaintiff suit. Of course, that the place of suing, and also
Mm-hmm.
the court,
Mm-hmm.
but draft the relevant pleading to take a bank case, noting the appropriate forum. But you must note in your pleading the appropriate forum. This is a
Mm-hmm.
forum for suing.
Mm-hmm.
So you did this.
Yes.
Yeah, you did. So that the other question, I did not take them. I did not. Sorry, I did not check the time you took. Let us go back there.
Okay.
Because timing is very, very important. I told you to be dedicating here time.
Yes.
So you see now here you say you used 39 minutes.
Yes. In the first one.
Can you imagine?
In the first, the one we've just talked. Yeah. 39 minutes.
So that's why I'm telling this is a waste. You can't do a question on 39 minutes. A question of 5, I told you a question of compulsory 50 marks, to 20 marks. 20 marks is if you are drafting the complete there's no theory question you are drafting. We said you use around how many minutes?
25.
No, not 25.
Of 20 marks, you use 50. I saw 57 minutes.
No, let's go there again. Note this, write somewhere.
Okay.
So if it's a question of 20 marks, and you are drafting everything, use 50 minutes.
Okay.
If it is a question of the half of that 10 marks, this is excluding the other question. Use 25 minutes. So if it is a question of 15 marks, you use around 38 minutes.
15 marks.
Yes, 38 minutes. If it is a question of 5 marks, use 13 minutes.
Yeah.
So you ought to have used 13 minutes. If you use 39 minutes in an exam, you will not be able to navigate well.
Okay.
And also, I accept when you do this assignment, you don't look somewhere. You do it like a test.
Yes.
You don't look somewhere because yeah, that is a training. Because if you look somewhere then you draft, you be lying to yourself. Then I see you unajua na kumbe ujui, unaona. So you understand the structure. It's better I come and correct you then ujue unajua. Then you also time yourself. That's how you pass. And this is the same instruction I gave to the last your colleague last year. And many of them did well. So let's go to the next question. So the question tells you, assume there is no defects in plaintiff suit, draft to the relevant pleadings to take care of the bank interest, noting the appropriate forum. So I want to project your answer. This is your answer, correct?
Yes.
So this answer is not correct.
Mm-hmm.
So the appropriate forum is, we said is the High Court in, you can put High Court in Machakos or Nairobi.
Nairobi.
Yeah, yeah, and you can even be more specific and put Commercial Tax Division.
Mm-hmm.
Then, so if you are replying to a plaint, how do you reply? From your civil procedure.
You use a defense.
Yeah. So that is the
Mm-hmm.
answer is defense and counterclaim.
Okay.
So they are supposed
Okay.
to do a defense, and then they counterclaim everything they are saying here. In fact, is the defendant, is the plaintiff who had defaulted,
Mm-hmm.
and judgment be entered against them. So I want you to do this.
Mm-hmm.
I want you to go and to draft a defense and a counterclaim.
Mm-hmm.
Tomorrow is a holiday. We are going to have another class, so you are going to send me in advance.
Okay.
So the answer is defense and counterclaim.
Mm-hmm.
Yeah. So that's why I'm saying it's very always to know how to know the pleadings and even how you reply to pleadings. Yeah. So plaint, you
Mm-hmm.
reply with a defense and a counterclaim.
Mm-hmm.
A petition, you reply with, if you reply to a petition,
I'm not sure.
replying affidavit. It's a replying affidavit.
Okay.
If it comes in exam, if it is an originating summons, it's not an application. You are replying, also replying affidavit.
Mm-hmm.
So those are the
Okay.
main three main. Yeah, those are
Mm-hmm.
the main. Yeah, those are the three main thing.
Mm-hmm.
So you must know the things that replies to various pleadings,
Mm-hmm.
and it can come in an exam. So that is your homework also,
Okay.
So we go to the next question,
Mm-hmm.
and I'm going to project the question paper. So question 2, we are there.
Mm-hmm.
You see now, like this question is 10 marks,
Mm-hmm.
1C. So you use, we have said 25 minutes,
Mm-hmm.
So that is defense and counterclaim.
Okay.
So that is you do a big now, no, a bigger document more than the one for 5 marks.
Uh-huh.
So we got to the next question. Question 2, you can see the question paper,
Yes.
So Hassan Mujaja saw the services of Alpha Omega Advocates LLP to represent him in a breach of contract claim against Sumpayo Moses. The matter was filed in court on January 1, 2016. The hearing of the case was concluded on April 23, 2023. The damages sought in the claim were 10 million. Soon after the close of the defense case and filing of causes submission as directed by court, Hassan Mujaja got his his son Wakili Kurutu, a lawyer of his own hand, to file a notice of change of advocates, taking over the conduct of the matter from Alpha and Omega Advocates LLP. Alpha and Omega Advocates LLP filed a bill of course against Hassan Mujaja. The same has been taxed to Kenya shillings 5.2 million, out of which 5 million is in respect of his taxation fees. Hassan Mujaja filed a reference from the decision of the taxing master challenging only one aspect of the taxation, that is the instruction fees awarded. Write a reason ruling on the application. So I want you tell me your understanding of this question. What is it? Of course, is you write a ruling. You must know in our last class how a ruling should look like: the heading, the parties, brief facts or arguments by the parties.
I'd like to.
Then the issues for determination, analysis by the judge, and the orders or disposition.
Okay.
So
in both papers,
yes,
I did not manage to do the rulings. I did the other applications, though I can send the rulings, and then there's also another question on appeal which I plan to send tomorrow. I didn't manage to do the rulings and one question on appeals in the 24 paper, but I can send them tomorrow.
Very good. So I'll give you a chance, you do it, eh?
Yes.
Yeah. So you are going to send, even question 3 is a ruling, eh? You are
I'll do them.
handling the fire certificate. Proceed to consider application and write a ruling. So I want also to give you an opportunity, eh?
Okay.
It's better you do the question first, eh? Because if you do the question first, so now we are looking at it, even you understand more.
Yes.
That is usually what we are going to. That is what I usually like to do, eh? So we are going to end our class there. But before, let me do a closing, maybe for the people who are going to watch online. Let me do a closing, then I'll stop the recording.
Okay.
So we have come to the end of the part 1 of the April 2024 civil litigation. If you want to pass these exams, I've already said what you need to do. The question 1, that things on place of suing and jurisdiction. That is some of the questions. The other question have been asked in the year 2008 to 2019 paper, which I've researched. So someone needs to go to the bar exam preparation website, purchase the paper, and see. So that was not it was like a repeated question. So the other papers I've researched are June 2021, November 2021, and April 2022. Then YouTube channel, by exam preparation website. We have done 3 papers now. October 2022, March 2023, which I did ahead of November 2023 exams with the last year's class. Then this year we have already done November 2023, which I uploaded. Now we are at April 2022. So purchase the papers and look at the YouTube channel, view, make notes, because I have also given predictions and many other things. They are not confined to the questions. So you need to read the papers and also listen to the YouTube channel to pass in this subject and see all the things that I've done said there. Yes, then subscribe to the YouTube channel and I'll be happy. So the next class is to part 2 is tomorrow,
Mhm.
10 October 2024, holiday. Good night.